Okay, Robert Mollett and Cynthia Rudder. Right.
Oh, okay.
Deborah Rudder's not here. So,
It's Richard Mollett.
the ones. What did I say?
Robert.
I got the R right, okay. Richard, you're right about that. That is your name. You are correct. What did I say wrong?
She's not coming, or the other one isn't here?
And Cynthia Rudder's not here?
No.
Oh, so it's just you?
Yeah, I don't know.
Oh, because we had three of you together.
Yeah, I don't know. Just,
Okay, well, do you swear that your testimony will be the truth?
I do.
I think number 4 is here. Is Carla?
I was, oh, well, I already called her.
Okay.
They
Oh, do you
told
want
she
me to go
wasn't
back?
coming. No, no, this is fine.
Okay.
They specifically told me she wasn't coming. Oh, she, okay,
So she'll go after.
okay. Okay,
Great, thanks. I'm actually going to buck the trend, and I am going to read from my testimony, but not in its entirety. Thank you very much for inviting me here today to testify on this issue, which is extremely important to us and to our community. I'm the Executive Director of the Long-Term Care Community Coalition. We are a nonprofit organization dedicated to improving care for residents in nursing homes and other residential settings. My testimony today is going to focus on the impact of pre-dispute arbitration agreements on residents in long-term care, particularly those in nursing homes. And I was glad to see that it came up for a number of the other people who testified today, because I think it is obviously an important issue. Forced arbitration hurts nursing home residents, their families, and taxpayers in New York State. And we want to get to both the personal issues as well as the more systemic issues related to taxpayers. Nursing home residents, as we all know, are among our most vulnerable citizens. By definition, they require 24 hours a day monitoring and care. When an individual needs nursing home care, it is typically a situation that is highly stressful, with limited time or opportunity to consider options and make choices. Mom had a medical emergency and wound up in the hospital. Now the hospital is pushing her to get out, and she can't live safely at home. Family has a couple of days to figure out what's going on with Mom's health, her finances, her house, her insurance, and get her into a nursing home. It is in this process that Mom, perhaps with a family member, will be given a pile of paperwork to sign. If there is a pre-dispute arbitration agreement in the pile, Mom and her family have just signed away their constitutional right to ever go to court should she be harmed at any time in the future due to substandard care, abuse, or neglect. 6 months from now, you find out that Mom has been physically or even sexually abused by staff. You are bound by the facility's arbitration agreement. A year from now, you find out that nobody has been monitoring or repositioning Mom according to her care plan, and now she has horrible pressure ulcers. You are bound by the facility's arbitration plan. 2 years from now, Mom has a stroke and dies after being chemically restrained with dangerous antipsychotic drugs without your consent. You are bound by the facility's arbitration plan. In reality, there is little or no opportunity to read, no matter review and consider, the terms of mandatory pre-dispute arbitration agreements in nursing home residency contracts. Moreover, even if arbitration agreements were explained, residents and their families would be highly unlikely at the time of admission to be anticipating the need for litigation against the facility. They would be hoping and expecting that care would be excellent. They would not want to indicate to the facility at admission that they were expecting problems and poor care. In addition, unlike other commercial settings, nursing home residents cannot, generally speaking, walk out when their nursing home abuses them or provides substandard care. They are often literally a captive audience for the nursing home. I also wanted to get to how this affects New York State taxpayers, and I'm glad that one of the previous people had mentioned that as well. Nursing home care in New York State is a multi-billion-dollar industry. Most of that care is paid for by the public through Medicare and Medicaid. When nursing homes are not held accountable for providing decent care that meets minimum standards, it means that taxpayers are paying for services that are subpar or even worthless. In addition, we also wind up paying for the ramifications of that care, hospitalization, extra treatments, et cetera. That all goes back to the taxpayer. Importantly, lack of accountability perpetuates a system in which it is both acceptable and profitable to provide poor care for nursing home residents in the state. Poor care persists in our nursing homes for one simple reason. The State Department of Health systematically fails to enforce minimum standards and ensure that residents are safe. And in the absence of meaningful enforcement, the ability to sue for serious abuse, neglect, and wrongful death is often the only way to hold providers accountable when they fail us. It also sends an important message to the industry that they will be held accountable when they fail our residents and fail to provide value for the money we pay them. So again, to me, it was just so important to get across that this has dual ramifications, and it does, in essence, save the state substantial money. I don't think that it's a substitute for enforcement, but unfortunately, in the absence of enforcement, it's something that is really necessary. I'm not going to go into detail about some of the reasons why and the data that I presented in terms of why we need greater accountability. I just wanted to mention a couple things. Families for Better Care, a nonprofit organization in Florida, does a national nursing home report card. They found in the last report card, which was 2014, the quality of New York's nursing homes care continues, to be dreadfully poor. The state's nursing homes continue to be chronically understaffed. New York remains anchored at the bottom in its nursing home care. We did a study last year that looked at safeguarding nursing home residents and program integrity, again, looking at both whether New York's 100,000 plus New York State nursing home residents, are safe, getting the care that we're paying for, and also whether we're getting good value for the money, the billions of dollars that taxpayers put in every single year to nursing homes. We found that New York's citation rate is among the lowest in the country of any state, that New York State Department of Health only finds harm when it cites a facility 3.33% of the time. Low citations, almost never finding that the violations have caused harm to residents. And we looked at actually several areas that we thought were important indicators of quality and safety. Antipsychotic drugging, there's a black box warning by the FDA against using these drugs on elderly people with dementia. Almost 20% of New York State nursing home residents are being given these drugs despite that black box warning. New York State's off-label drugging is now approximately 18%, doesn't include the on-label drugging. Yet we only cite nursing homes for inappropriate drugging about a quarter of the national rate. We're just not holding nursing homes accountable, and residents are paying the price, and taxpayers are paying the price. We also, regarding pressure ulcers, New York State has for years, our State Department of Health has had this program. It's called the War on the Sore, which I think is a really obnoxious term for a program. But basically, they handhold the industry to try to get them to do better. New York's rate of pressure ulcers is still almost 9%, which means over 9,000 people today are in nursing homes, and our nursing homes have pressure ulcers. They're almost always preventable or treatable, given appropriate care. Yet New York's annual citation rate for poor pressure ulcer care is a fraction of the U.S. average at 0.88%, the second lowest in the entire country. We're just not doing anything about it. And this is why, and you'll see the testimony from Deborah Jahaski, who's on my board, and she does a number of cases in this area, that nursing homes are just missing the boat, and the only chance that residents have of having a voice, of being able to really be heard on these issues and get any kind of response is when they are able to go to court. And again, we as consumer advocates rely on that because the state is not holding nursing homes accountable. It's really only through the courts. We do a lot of advocacy to try to get the state to do a better job, but it's just not happening. Lastly, in terms of the data, I wanted to mention also that the U.S. Inspector General did a study 2 years ago that looked at the outcomes for Medicare residents in nursing homes. These are people who go in for short-term stays. The average payment that we pay as taxpayers, $500 to $800 per day for these residents. 1 out of 3 of them, the U.S. Inspector General found, was harmed within 30 days of entering the facility, and almost 60% of that harm was preventable. Even when they're being paid top dollar to provide care, there's no accountability, and the care is poor. So we need to have these safeguards in place. Just a couple of recommendations. I wanted to mention, this wasn't in my written testimony, that one of the things that California does have is, they have staffing standards, and New York State is one of the minority of states that does not have minimum staffing standards for our nursing homes. But as part of their staffing standard law, they have a right of action. I believe it's for the state. But basically, for a nursing home that falls below their staffing levels, they can be fined I think it's $500 per day per facility. And there was a major case a couple of years ago that found, I think it was about over $600 billion. Wound up being settled for substantially less, but it sent a tremendous message to the industry about staffing. So this was a way in which the state codified an important safety consideration in its law. And you had talked about that a bit before, which is why I wanted to mention it. My suggestion is that I think the committees, and the Assembly should really be looking at what's going on with the federal requirements over the next year. The CMS, is right now revising all of what's called the requirements for participation, which is all the federal regulations. And one of the things that we and other consumers have urged is that they state unequivocally that pre-dispute arbitration is not appropriate in the nursing home setting. We believe that they have the authority to do that. Whether they will do that or not is another story. They also, in many ways, beholden to the industry. But it's important, I think, because in my experience, at least in New York, is we don't generally have an opportunity to pose a number of different bills that may or not be good and powerful. We get one or two opportunities, and that's it. And I would hate to waste an opportunity on something that's then going to be shot down by the Supreme Court a year from now, and then not have the opportunity to really address that again. So I hope that makes sense. I think that there's a lot going on federally. The reason why we don't have this protection anymore in New York is because of federal preemption of the state's protection against it, and I think that we should wait and see to a large extent. I do think that the Assembly Bill 8108, which we were asked to comment on, I think that would be a positive step. I think we do need, as others have said, a lot more transparency, and I think that would be hugely helpful. And I'm going to stop there. Thank you.
Based on what you know, these arbitration clauses with respect to nursing homes, is that pretty universal at this point, or some have it, some don't?
I think my understanding is that very few have it because of the state's laws in the past. The state law has always been that you cannot have forced arbitration in a nursing home agreement, and that's only changed as a result of the federal case.
So, do you have any data on how many nursing homes have it
No.
at this point?
Yeah.
But is your sense that most of them do, or no?
My sense is that if they don't now, that they will. I know that the assisted living providers, almost to my knowledge only, and I haven't looked at all those agreements at all, but to my knowledge, most of the assisted living providers do. That's always been a big issue for us because the law, when New York State passed the assisted living law in 2004, that was something we would have liked to have seen included, but it was just not something that was politically possible, to be honest, because the industry's influence in that law. So people who go to assisted living, and this is, to be honest, a significant issue because more and more it's the same people going to nursing homes as are going to assisted living, people who can't live safely at home any longer. But if you go to an assisted living, you're SOL, to be perfectly blunt, if you have a problem down the line. I mean, it's really up to whatever the provider has said they were going to do and what's in that contract, whereas historically, until recently, if you are a nursing home resident, you had the right to go to court. So that was a major difference.
I have to agree with you on one thing. 108 is an excellent bill.
I hope you're agreeing with me on more, though.
Well, that's one of the things that I might agree with you on. Nothing? Okay, thank you very much.
Sure, thanks.
Yeah. Okay, Carla Gilbride.
Good morning.
Do you swear your testimony will be the truth?
Yes, I do.
Okay.
Thank you, Chairman Dinowitz, Chairwoman Weinstein. Thank you to the members of the committees for inviting me to speak here today. I want to apologize at the outset for my late arrival and for missing some of Mr. Carbonello's remarks. My train from DC was delayed, but I'm very happy to be here. I am a staff attorney at Public Justice, which is a nationwide public interest law firm engaging in high-impact litigation to defend the rights of consumers and low-income employees from corporate abuses. And one of the corporate abuses that we've been spending a lot of time combating in recent years is the increasing use of mandatory pre-dispute arbitration provisions buried in the fine print of sales documents, nursing home admissions, as we've just been hearing, paperwork, and increasingly employment applications, so that people on almost a daily basis and without realizing it are giving away their constitutional right to a trial by jury. And what you'll hear often, and in fact we've heard it today from Ms. Tully, we hear from advocates of arbitration that this giving away of rights isn't a big deal because arbitration is just an alternative forum for resolving disputes. And in some ways it's a superior forum because it's quicker, the courts are overburdened, it's cheaper, and it's less intimidating and better for consumers all around. But that's not what the data shows. For one thing, arbitration is often far more expensive than going to court. Many arbitrators charge hundreds of dollars an hour for their time. And a consumer often doesn't know up front how much of that bill is going to fall to them. While sometimes it is true that the arbitration provision will stipulate that the costs will be borne by the company, often the cost allocation decision is left up to the arbitrator. And so, the consumer has to roll the dice as to how that's going to come out and may have to advance those costs during the pendency of the arbitration, hoping to be reimbursed down the line. And that's just not a risk that many consumers are willing to take, especially if the claim that they want to resolve is a fairly low-value claim. And that's why, alluding to something that Mr. Seligman discussed earlier with respect to the CFPB study in March of 2015, there are very few low-value claims, claims of just a couple $1,000s being resolved in arbitration. Specifically, the CFPB studied AAA arbitrations in the 6 consumer financial product markets that they have regulatory authority over. So it's credit cards, payday loans, student loans. And they found only an average of 25 per year between 2010 and 2012 that were being brought for under $1,000. The New York Times, in the series of articles a lot of people have been referencing today, found something similar. They studied arbitrations on multiple arbitration providers between 2010 and 2014 and found only 505 brought by consumers seeking $2,500, $2,500 or less. So obviously arbitration is suppressing claims on a massive scale, especially small value claims. But even for those consumers who do proceed to arbitration, the idea that it's easy, you can go in even without a lawyer and you'll do fine, that doesn't hold up to empirical evidence. Again, the CFPB study surveyed and reported on the affirmative claims that consumers brought in arbitration and found that they prevailed about 20% of the time and received, when they prevailed, this doesn't count for when they lost, the 20% that prevailed received about 57 cents on the dollar. By contrast, when a bank or a lender filed arbitration against a consumer, they won 91% of the time and received 93 cents on the dollar that they sought. So consumers are not doing very well in arbitration. And in my written testimony, I provide similar empirical evidence with respect to arbitrations on employment claims. But for the sake of brevity, I'll move on. We can kind of take it as a fact that to the extent we have evidence, and we don't have a lot because of the secrecy and the confidentiality under which a lot of this arbitration goes on, but to the extent that we have data, it shows that the corporate players, the companies, tend to do a lot better. And there are, I'm sure, a lot of reasons for that, but certainly one reason for that is this repeat player effect. The idea that while a consumer or an employee is going into arbitration probably only once in their life, the employers and the big businesses are going over and over and over again. They're often represented by the same counsel, and so they're able to learn the system and learn the arbitrators and learn how to argue and advocate in that forum most effectively, and even seek out particular arbitrators who are likely to be friendly to them and blackball or not do business with arbitrators who are not likely to rule in their favor. One particularly striking example of the repeat player effect was recounted in a 2015 paper by the Economic Policy Institute, where Alexander Colvin surveyed arbitrations between 2003 and 2014 involving employment, documents that had a pre-dispute mandatory arbitration provision, and an arbitration eventually, proceeded under that document, and found that when an employee and an employer were both, first-time participants, the employee had a 17.9% chance of prevailing. But when you controlled for the same employer had now, been in the system and was arbitrating against a new employee, for the fifth time. So the same employer has now been arbitrating over time, and they're a fifth-time repeat player with a new employee adversary. That employee's chance of prevailing goes down to 15.3%. And by the time the same employer is arbitrating for the 25th time using the same arbitrator, the employee's chance of prevailing is down to 4.5%. So that really underscores the importance of disclosure and bills like A108, which will, unveil some of what's going on behind the scenes and beneath the surface, so that consumers and employees who do have to go into this forum have a little more of an information symmetry about what's happened in the past, how arbitrators have ruled, and who the repeat players are and who the repeat winners are, so that they can make more informed decisions when they're selecting an arbitrator. So I will stop it there. There's more detail in my written testimony, but I'm happy to answer any questions that anyone might have.
Okay, anybody have any questions? No? I guess you were comprehensive and complete. But I do think the information just presented on the percentages of victory for the employees is particularly striking, and underlines the importance of Assembly 108, because clearly it suggests that repeat arbitrators, certainly repeat employer parties win very often, but I think it's clear that those arbitrators who do this a lot and who want to continue to do it a lot tend to rule against the consumer, almost always.
Well, if they want to have business, that's that is self-interest, and I'm not trying to cast aspersions on arbitrators as being, unethical. I think, obviously, disclosing information about potential biases is also a good move for, in terms of having freedom of information in the marketplace, so that everyone, knows what's going on. But I think it's simply a reality that when you have a private system where people are sort of competing for business, that one of the ways in which you make yourself a successful participant in that market is by making yourself attractive to the repeat players, to the people who are going to be bringing you case after case after case, and that's what you see in that study of, it's over 2,800 arbitrations over an 11-year period, and it showed that the more times employers kept going to the same well of the same arbitrator, the more likely they were to prevail.
Would that sort of be, I don't want to draw an unfair analogy, but if the district attorney always had the ability to pick which judge was hearing a case, there might be a tendency to be on the winning side more often than would otherwise be the case.
Sure, and I would submit that that's why people don't get to pick which judge they're in front of in the public court system, to guard against just that kind of tactic.
Okay, Helene?
Yeah, just was wondering if, like some of the others who spoke before us, if you've looked at what kind of statute we could do in New York to help protect in particular consumers that would not be preempted?
So I would agree with many of the suggestions that Mr. Seligman made with respect to, the idea of a market participant. And I know that something similar has been introduced in the New York State Legislature, or at least in the New York State Assembly, in the past regarding contracts with companies that force employees to arbitrate civil rights and sexual harassment claims, kind of modeled on the federal executive order. And my suggestion is that the state could go further than that, that it doesn't have to be limited to, companies that arbitrate or force their consumers or their employees to arbitrate particular types of claims, but that you could refuse to do business with companies that force arbitration at all in a pre-dispute sense, that we've been talking about. So that's an option that could certainly have given a state, of New York's size and stature and the sort of, the number of contracts that you engage in, that would have a large effect. Other things, Mr. Seligman mentioned insurance, which is fair game, and I think that you'd have a safe road to regulate insurance as a state in a way that you can't regulate other particular types of claims without running into FAA preemption. And I guess the last thing that I would say is, anything that applies to contracts generally, whether it's, requiring more informed consent or contracts terms to be displayed and made prominent, and perhaps even giving people a chance to reconsider or opt out. And I'm thinking a little bit out loud here, but anything that you do to sort of regulate material terms of contracts that is not limited to arbitration at least has a shot. You still might run into an argument that, well, they say it applies to all contracts, but really they're going after arbitration agreements. But, the Supreme Court has said over and over again that, arbitration is a matter of contract, and it should be, arbitration agreements should be considered under the state laws governing contracts generally. So if you pass a state law governing contracts generally, and that happens to also apply to arbitration agreements, that would be a more a path that might have more success.
Thank you.
Thank you.
All right.
Thank you.
Thank you for being here. I think Rich was
Nicole Arundel. Good morning. Do you swear your testimony will be the truth?
Yes, I do. Good morning, and thank you again to the chairs for holding this hearing and considering this important issue. My name is Nicole Arundel. I'm a staff attorney at MFY Legal Services here in New York City. MFY is an organization that envisions a society where there is equal justice for all. And our mission is to achieve social justice. We prioritize our needs, our services to those who are low income, disabled, and people with disabilities. We provide high-quality legal services to over 10,000 New Yorkers every year. Specifically, our Consumer Rights Project works with low-income New Yorkers in providing advice, counsel, and representation on a number of consumer issues, particularly predatory lending, as well as abusive debt collection practices. We view mandatory arbitration as an economic justice issue, and we commend the Assembly for examining ways to better protect New Yorkers against unfair mandatory arbitration clauses. As was mentioned earlier, the New York Times published that 3-part investigative series on mandatory arbitration, and that highlighted the experiences of American families, many like our clients. It also illustrated how mandatory arbitration can undermine consumer protection and how it impedes individuals' access to justice. Through our work at MFY, we see firsthand how mandatory arbitration impacts low-income consumers It impacts nursing home residents that we serve and low-wage workers. Our testimony today will highlight some of these issues and concerns. Our written testimony has many more details. Mandatory arbitration clauses are included in practically every consumer contract that our clients deal with. Again, we serve low-income populations. They see these in their prepaid call contracts, their credit cards, cell phones, and internet service, as well as their nursing home admission contracts, and even in some of their non-union employment contracts as well. Many of them are unaware that these clauses exist in contracts when they sign up for a particular service or for the purchase of certain goods because, as Assemblymember Denowitz pointed out, they are buried in the fine print. And even the most sophisticated of us don't read these, and that's what happens with many of our clients. Even if they are aware of those arbitration clauses, we find that many of them don't understand what they mean. They don't understand that this is limiting their rights to go into a court of law. And many of them obviously don't have the power to negotiate these. They're form contracts that they're locked into. If someone wants to purchase a cell phone or a car, they are forced to accept arbitration as a means to settle any disputes related to those goods. And while arbitration may be an effective tool for corporations to settle their disputes in a business versus business context, we find that the system is inevitably biased and rigged against low-income consumers and low-wage workers. Mandatory arbitration deprives them of their right to seek justice in the courts. It systematically favors the corporations who know the rules, many times have helped to write the arbitration rules, and those companies choose the arbitration forum. Arbitration also is very financially burdensome for low-income individuals. We think that access to justice is important. It's obviously a fundamental right, and low-income consumers have far more access to justice in the court system than they do in arbitration. And I can give you an example of that. It was mentioned earlier by Ms. Tully that the court system is clogged and there's so many cases and that it's very hard to navigate. When it comes to consumer debt cases, New York has seen a stark rise in a number of those types of cases, debt collection particularly, coming to the civil courts, coming to Supreme Court. The consumer advocates around the state have banded together and have put together a number of initiatives to help low-income consumers particularly, and any other consumer, when they are defending those types of cases. The court system itself has also worked to ensure that if a self-represented litigant goes into court for a consumer debt case, they will have tools available and resources available to them that can help them navigate that particular court case. For instance, there's a volunteer lawyer for a day program that's available to anyone in consumer debt cases. There's the Civil Legal Advice and Resource Office. There are pro se forms that literally give people guidance on how to fill out an answer or how to file certain papers. There are fact sheets available, interactive online forms, etc. Those are some of the things that are in place for self-represented litigants in defending themselves on a consumer case in court. In stark contrast, arbitration forums don't provide assistance to pro se individuals. Those self-represented participants in arbitration don't have such type of guidance or resources available to them. Many arbitration clauses can also require that a participant take that arbitration in another state, and sometimes that state is not even a nearby state. We have an example of that at MFY. We worked with a low-income consumer who contacted us for help. He was shocked to find out that his arbitration clause in a contract for his a contract that he had with a company that was to give him money in helping out on a personal injury suit. That contract required him to travel to Texas to defend the arbitration proceeding that the company had commenced against him. So to defend this particular arbitration, a low-income consumer in New York who entered into that contract in New York would have to travel to Texas to defend himself for that particular matter. So to us, the claims that are made by arbitration proponents that arbitration is faster, it's cheaper than litigation, those fail to take into account the financial barriers that exist for low-income consumers. The high cost to file these cases and to defend them in arbitration can preclude low-income consumers from resolving their claims. As was mentioned earlier, I believe by Ms. Tully, it costs about $200, which seems minimal to many people, but not to those 10,000 clients I mentioned that we serve in New York who are low income. $200 is a barrier for them to enter that type of negotiation. In comparison, there's no cost for a consumer to defend themselves in a debt case in New York civil court. And while there might be fees that occur for them to file a case in those courts, many times in our experience, low-income consumers qualify and do receive fee waivers so that they can file those cases. We encourage the New York State Legislature to look at ways to ban mandatory arbitration and to enact laws that increase the transparency, the fairness, and accountability, particularly for those consumers who are of low income. The Assembly Bills A108 and A8191 take a step in this direction. We think that by shedding light on the secretive system of arbitration is a way that can be helpful to consumers, increasing transparency. We also support the national advocates who've spoken as well. The National Consumer Law Center talked about their Model State Act, and in our view, this is something that is worth pursuing, particularly provisions around municipalities doing business with companies that include these arbitration clauses in their contracts. Again, MFY thanks the Assembly for recognizing the urgent need to address these unfair and mandatory arbitration clauses, and we would welcome the opportunity to work with the Assembly to particularly look at how this impacts low-income consumers and consumers with disabilities in dealing with arbitration. Thank you.